From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The U.S. Supreme Court strikes down Joe Biden's student loan forgiveness plan. What was its reasoning? What does it mean? And what comes next? Welcome to Potomac Watch. I'm Kim Strassel. I am joined today by two experts on this subject, my colleagues Alicia Finley and Mene Ukwe-Barua. The Supreme Court, on its final day of its session, issued its ruling in Biden v. Nebraska. This stems from the president's move last year to outright eliminate the federal student loan debt of most borrowers with a wave of his magic wand, a plan that would have cost taxpayers at least $430 billion. A number of parties sued, including a nonprofit corporation in Missouri that said that the debt elimination would harm it financially. And today, a 6-3 court struck down the loan forgiveness, saying that the 20-year-old statute the administration relied on for its authority to do this in no way, shape, or form, in fact, gave the Biden administration the right to go around Congress and cancel this debt on its own. The opinion was authored by Chief Justice John Roberts, joined by the 5 other conservatives on the court, the dissent written by liberal Justice Elena Kagan, and joined by Sonia Sotomayor and Ketanji Brown Jackson. So, Alicia, this is huge, and in my mind, a much-needed brushback of a pretty egregious abuse of authority. But before we get to that, why don't you just lay out what this statute was that the administration was leaning on and John Roberts' view of the verb to modify.
So the 2003 HEROES Act was enacted in the wake of 9/11, and it was really mainly intended to help veterans and military members who were returning from overseas and needed a little bit of flexibility to make their student loan payments. And so this law allows the education secretary to waive or modify regulatory or statutory provisions of federal student loan programs, that would be both Pell Grants or student loans, when he deems it necessary in the event of a war or national emergency. These were intended to kick in very discrete cases, and presidents in the past, George W. Bush, used it again in very discrete instances, mainly waiving paperwork burdens for veterans and such. Now, what the Biden administration claimed, they claimed that they found this new authority. And actually, to back up a little bit, the Trump administration bears some fault in this too, because when Congress declined to extend student loan payment pause and pause on interest accrual that was enacted by Congress in the CARES Act in March 2020, the Trump administration claimed that he had the authority to do so under the HEROES Act. This authority to modify and waive allowed it to therefore modify and waive any payments for essentially during the duration of the pandemic or national emergency. And as we discovered, the quote-unquote national emergency just dragged on and on and on. Yet nonetheless, President Biden, actually just a few weeks before declaring that the pandemic was over, he leaned on this law in August 2022 to cancel debt about $10,000 to $20,000, nearly 42 million students. Now, this law has never been used to the extent that President Biden did, and never even close. And as the Chief Justice Roberts says in his opinion, the administration modified the student debt, or to the extent that the French Revolution modified the status of the French nobility. It has abolished them and supplanted them with a new regime entirely. Touché. Now, Congress could have actually enacted this on its own. It had plenty of opportunities to do so. Nancy Pelosi in July 2021 actually said, when asked about this, could the president on his own cancel student debt? She basically said, absolutely not. This is the prerogative of Congress. So even Nancy Pelosi herself disputed that the president had the authority to do so. And so this really wasn't a partisan question or issue, and nonetheless it became so because all of a sudden the media and liberal activist groups tried to portray the court and basically just saying that no, the president doesn't have the authority to serve Congress, that this was some kind of judicial activism. But I think really that this should have been a 9-0 decision.
Yeah, that's what really strikes me about this is how unsurprising the ruling is, in part because of what you're just noting, Alicia. Some of the main witnesses, as they were, that the plaintiffs relied on this case were Joe Biden himself, who said in a CNN town hall in 2021, when asked if he had had the power to do this. Quote, I don't think I have the authority to do it by signing with a pen, end quote. And then, as you note, too, the court actually quoted Nancy Pelosi, her statement, also in 2021, in its opinion. And that statement was, quote, people think that the president of the United States has the power for debt forgiveness. He does not. He can postpone, he can delay, but he does not have that power. That has to be an act of Congress, end quote. But Monet, the other reason that's not so surprising to me is simply this particular court's growing focus on reining in the bureaucratic state, the executive branch. The opinion noted the enormous economic consequences of this student loan forgiveness, the size of the debt that was being forgiven, and referenced numerous times the major questions doctrine, or the notion that the courts will take the view that Congress does not delegate to executive offices issues of major economic or political significance without expressly saying that that's what it's doing. You can't just magic it up out of some vague word in an old statute. But I'm wondering, Monet, if you agree with that this has been something that really has been a focus of this court.
Oh, it's absolutely been a focus of the Roberts Court. You could say that reining in administrative overreach is now the signature issue on which the court has made a lasting imprint on American jurisprudence. It is very clear that just within the past 2 to 3 years, there have been several decisions from the court's conservative majority that basically suggested that administrators had less power than they had arrogated for themselves to push massive agendas through slight ambiguities in the law. And we've seen that, of course, in environmental regulation. We had West Virginia versus EPA, in which the Environmental Protection Agency's powers were reined in significantly. We've also seen it in the court's rejection of the eviction moratorium. Basically, the CDC had used emergency powers to suggest that nobody could be removed from their rentals during the course of the pandemic. As Alicia mentioned, the pandemic federal emergency ended up lasting for several years. And eventually the court, after initially suggesting that this moratorium could continue temporarily, decided that there must be some time limit and that it wasn't within the emergency powers of the CDC to permanently or indefinitely prevent landlords from exercising their right over their own properties. And we've also seen it in rulings on immigration. We have seen that Department of Homeland Security has exercised broad leeway over its ability to defer deportation actions, for example, of certain classes of immigrant. And yet we now see that potentially about to be revisited by the court in the sense that, yes, this agency does have discretion over some of these decisions, but they can't permanently and indefinitely give forgiveness to an entire class of aliens in a way that Congress has not explicitly allowed them to do in law. And so the principle here is that the rights of these executive agencies are enumerated. Of course, there are some ambiguities in the law, and they do have certain amounts of discretion, but it is very clear in the Roberts opinion that you cannot read limitless power into any ambiguity in the law, because it would be completely impossible for legislators to perceive beforehand every single abuse that might take place within these agencies. And so the Supreme Court has consistently applied the principle that there must be reasonable restrictions. If something isn't explicitly allowed, you must look to precedent and see whether the actions being taken by the executive branch are consistent with Congress's intent. And if they can't clearly demonstrate that, the court will be willing to bring them back in.
Hear, hear. And by the way, that perfectly tees up the minority's opinion, which I just want to talk about a little bit. Elena Kagan, who wrote the dissent, her rationale for dissenting seems to go to the exact opposite of what you just laid out, Monet. And I'm putting aside here, the dissent spent a lot of words arguing over whether Missouri even had the standing to sue, which is a different question. We don't necessarily need to get into that. But on the merits, the minority's view is, in my mind, is a pretty kooky theory, which is that if Congress didn't expressly forbid something, then anything goes. Kagan says essentially that the Secretary of Education was given broad discretion here. Congress didn't say that he couldn't do it. And I quote, that may have been a good idea or it may have been a bad idea. Either way, it was what Congress said, end quote. And, Alicia, that just seems to me to turn everything on its head. Anytime Congress gives the slightest bit of discretion, it should just be assumed that bureaucracy can do anything they want. I mean, what do you make of that theory, Alicia?
Well, I think that's not right. But what we saw in the Justice Kagan's dissent is actually what we've seen in the other cases, the major doctrine cases that come before the court, notably the vaccine mandate eviction moratorium and the Bomb Clean Power Plan, the West Virginia EPA last summer. And that is, unless Congress forecloses something, the executive has broad delegation and has broad power to do essentially whatever it wants. Now, there's no limiting principle if you really consider what the liberals are arguing here in terms of, at least in student loan forgiveness or actually in any other realm. Could Biden wipe away or wave away all $1.6 trillion in student debt? Well, why not? Why not just waive all future payments for all students? Just say, oh, we're going to issue you loans. I mean, and then you will never have to repay them, right? There's nothing under the liberal justice's dissent that would suggest that they couldn't do that, or that the president couldn't do that. And I find this very disturbing. And I think if you read the Chief's opinion and if you juxtapose it to the Justice Kagan's dissent, it's very clear that she is trying to relitigate West Virginia v. EPA. Again, that's the decision that struck down the Bomb Clean Power Plan under the major questions doctrine, but also just looked at the statutory text of what the Clean Air Act allowed. And what she doesn't like is she doesn't like any kind of limits on presidential power. Now, I think this to some extent is partisan. If you had Donald Trump or perhaps Ron DeSantis or any other Republican as president, there's no question that you would probably be striking down these kinds of executive overreaches left and right. I mean, if the case were to come before the court involving a border wall, whether Trump had the authority to essentially build the border wall without any kind of appropriations or legislative authority from Congress, there's no doubt she would reject it and would probably cite the major questions doctrine. So I think some of this is actually politically opportunistic on the left's part. And you can kind of see and read in the Chief's opinion that he takes the Justice Kagan to task for one, impugning the conservative justices and their own motives and suggesting that they're the activists and they're the ones who are engaging in partisanship. And that's in part because these kinds of dyspeptic attacks on the conservative justices and the majority are contributing to the erosion of public trust and undermining the legitimacy of the court, which is, of course, ironic because the liberals keep on accusing the conservative justices of doing that.
Yeah, I was glad to see that John Roberts included those lines. It's one thing to disagree with the rest of the court legally, but the minority here and in some other cases has really gotten a little personal and questioned the motives of the majority, which I think is a little beyond the pale.